the $30 car tab case, she used a completely, not she joined the unanimous decision in the $30 car tabs to strike down the people's, their initiative. The people came together. We're a pure democracy because of that, because of
Yeah.
the initiative process. They came together and it was struck down without, they didn't even blink. They make it so hard for the people to try to pass laws. That's pure democracy. I think that completely violates my judicial philosophy.
Yeah.
And then you see it again in the capital gains tax. I saw you talk about it. It's trickery with the words, right? I think it's just the best way to put it is intellectual dishonesty.
From Seattle to Los Angeles, this is Left Coast News. No apologies, just the truth.
All right, this is Left Coast News, and today I've got a special guest. His name is Karim A. Merchant. Karim Merchant is a criminal defense attorney running for position 7 on the Washington State Supreme Court in the August 4th, 2026 nonpartisan primary election. He's a former King County public defender. He's challenging the incumbent Chief Justice Deborah Steffens. And Mr. Merchant, you reached out to me this morning, I'm assuming after you saw my video, The Tipping Point, where I kind of broke down the people that I thought were the best option for more conservative, middle of the road leaning people. So why don't you tell me more about yourself and what your position is?
Thank you very much, and I appreciate you considering what I have to say. So my name is Karim Merchant. I was born in Cleveland, Ohio, to working class immigrant parents. I moved to Washington State when I was in the second grade. I was about 8 years old at that time. And I was a product of the public school system out here. I went all the way up till 12th grade. I spent 4 years getting my 2-year degree at Bellevue Community College, transferred to the University of Washington, and then went to Howard University School of Law in Washington to get my law degree. And then I came back here and began practicing as a public defender. I'll tell you, the reason why I'm running is because Washington is my home. I have 2 kids, 6 and 11. And I'm married. And I have a vested interest in their well-being. This is the place where they will grow. They will grow up here. My parents will grow old here. And so I'm really fighting to restore constitutional order on the state Supreme Court in order to save our state.
Okay. So I kind of searched the internet because honestly, I hadn't heard of you until you reached out to me today, and so I kind of checked the internet to see what it had to say about you. And what I got was that you're positioning yourself as a candidate who challenges the establishment and brings diverse perspectives to the court. Your focus is on equality and fairness, emphasizing the need for judges who understand the struggles of everyday people and act as constitutional checks on government power. You've practiced law for over 18 years, operating your own practice, and historically represented the common person, noting that you've never represented the government or corporations. Is that accurate?
That all sounds pretty fair. Yeah.
Okay. All right. And you're running against Chief Justice Deborah Steffens, who was originally appointed to the Supreme Court in December of 2007 by Democratic Governor Christine Gregoire, took the bench in January 2008, and she's won re-election in 2008, 14, and 20. She has been a consistent vote on major progressive milestones. Notably, she concurred with the majority opinion that abolished the state's death penalty, and she's been part of the judicial majority that cleared the way for the state's recent controversial gun and tax laws. So, all major concerns for people that are more moderate and on the right.
Yeah, because I can tell you that the Chief Justice, she has a philosophy that just happens. I don't know if I can't say that it's outcome driven, but it has a tendency to raise taxes, raise spending, and just increase the size of government. And so that's evident in like the McCleary case, the $30 car tab case. She used a completely, not she joined the unanimous decision in the $30 car tabs to strike down the people's their initiative. The people came together. We're a pure democracy because of that, because of
Yeah.
the initiative process. They came together and it was struck down without, they didn't even blink. They make it so hard for the people to try to pass laws. That's pure democracy. I think that completely violates my judicial philosophy.
Yeah.
And then you see it again in the capital gains tax. I saw you talk about it. It's trickery with the words, right?
Oh,
And
yeah.
excellence, right? It's so basic. Like you, I would love to take that opinion and staple it to my tax return and send it to the
Yeah.
IRS, because every time if I purchase a widget for $2 and sell it for $3, Washington says that $1 is not subject to income tax. That's bananas to me. That
Mhm.
is I'm sorry, I think it's just the best way to put it is intellectual dishonesty. And then that trend continues when just a couple months ago with the referendum, um, when the people attempted to invalidate the state income tax.
Mhm.
Um, they didn't go through any type of meaningful analysis in determining whether or not this was truly something that would fall under the necessity clause. It's their job to evaluate why the legislature believed the necessity clause applied. It's their job to make that independent assessment, and instead they just relied on case law without, independently showing the work. And
Yeah.
that's part of a long trend. They've politicized the branch to a point where there's just no longer any faith in the institution that it's fair. It has to be impartial. It has to be. And
Mhm.
and the only way that can do, you have to engage in the appearance of fairness, and you have to engage in a particular level of legal analysis that's just not dishonest the way they have been. So I plan on putting an end to all that.
Good. Good. Yeah, they throw that necessity clause around. They use the necessity clause even to build Safeco Field back when that was being constructed. And,
Oh,
they
really?
just, yeah, it just feels like, you know, from voters' standpoint that, and I get a lot of comments too from people when I post a lot of these videos that, Washington State's a lost cause and there's nothing we can do and all this. But I really feel like, if people will just go out and vote this year, because conservative voters historically just have low turnouts when it comes to voting in the primaries and stuff. And I just feel like if they'd actually go out and vote, maybe we could make a difference, especially this year with so many seats up, on the Supreme Court. It would make a difference because you're not just going to see the rubber stamping of all this stuff that the legislature pushes through. I don't know.
I agree. I think this is the year that it's going to happen because it's so historic how often you have 5 out of 9 seats. And
Right.
usually nobody, everyone's tired by the time they get to the judicial branch in the voters pamphlet, right? It's exhausting, but
Yeah.
at least it seems like this is the top ticket this year. So I think a lot more people are paying attention and they're starting to realize how much is at stake. I'm really glad you guys are out there vetting all of the candidates.
Yeah, well, I mean, it feels like, when you go to vote, like a lot of times you have no idea who's who on, especially when it comes to judicial stuff and all that. And people just don't follow that stuff as much as the other, big positions that end up being on the ballot. And so I just feel like you got to get that information out there so people are at least aware and hopefully remember the names that they should be looking at. I'm not going to tell anybody, you got to vote for this, but if we want to make a difference and get some more moderate people up there, then people are going to have to remember the names, and not just check a box and, oh, this person's been there, so just check a box, or ignore it completely, not even fill out the ballot for those positions, which also happens a lot. So, all right.
Yeah. Well, yeah, yeah, yeah. So this year, you were actually you're the first person to ask about Article 1, Section 24. I don't know if I mentioned this. I'm a constitutionalist. I'm a firm believer in the Constitution. It's not. I think that we can have the perfect government that the Constitution promises, as long as we just follow it. Um,
Yeah.
so, Article 1, Section 24 is interesting because so the Constitution we adopted was 100 years after the U.S. Constitution, and so I feel like our founders were able to like evaluate all the hypotheses of the forefathers of our country, right? Like the Federalists versus the Anti-Federalists, all of the ideas that went in and all the negotiations that went into the U.S. Constitution. The Washington founders had that ability to be able to reflect on those hypotheses and see 100 years of like data, essentially, right? Um, to see how they ended up standing up to the test of time. And I think that Article 1, Section 24 is like the best example of that, where,
Mhm.
they were trying to figure out how they wanted to have their right to bear arms, what that rule was going to be. And they looked at the Second Amendment and said, well, that's just not, you know, that's not enough. We need to have more and we need to make it clear. And they came out directly and said, and made it so clear that there's no ambiguity, that you have the right to bear arms in self-defense. That's
Yeah.
a constitutional right. Um, and our country's been around for quite a while, since 1889, and we don't have very much independent Supreme Court jurisprudence on Article 1, Section 24. Our state has quite a tendency to, because, they decide which cases they're going to hear. And so, every case has the right to an appeal. And usually that starts as a felony, only losers appeal. Someone loses at the trial level, it gets appealed. You're guaranteed that appeal. And whatever happens at the appellate level, the state or the defense, they have the right to try to ask permission or request that the Supreme Court review this case. And the Supreme Court looks at it and they can decide whether that's the case they want to review or not review. And so, that's how the Supreme Court, controls what the law is. And I have to check I feel like about every 6 months, I have a brand new constitutional Second Amendment issue that I'm raising at the trial court level, where I'm fighting for someone who's looking to protect those rights. And I always have to keep checking to see if there's been an update on whether they've addressed Article 1, Section 24. And guess what? Again, they just came out with the ruling. It was DUIs. Two DUIs would
Yeah.
I can't remember it after, but the point was, and I know the reason why it's standing out is that they did not address the Article 1, Section 24 issue in that case. What do you remember specifically what it was?
It's two DUIs and you lose your gun rights. And I don't know. I don't understand how they're tying that together. I mean, I understand the safety aspect, but most of the time people aren't driving around drunk and then doing something with a firearm. So it seems like the issues are unrelated. And they just had that federal case with the marijuana use, where some other state, I can't remember what state, tried to do the same thing where if you were convicted of using marijuana, of course, marijuana was illegal in that state, but you'd also lose your firearm rights. And the Supreme Court said no, that doesn't. So it'll be interesting to see how that, if it ties back to this alcohol issue too. But yeah, I mean, any excuse the state has to go after guns, they're going to do it. So
Well, that was the perfect opportunity to address the meaning of Article 1, Section 24. I mean, I can't, they're constantly have this opportunity and they just refuse to take advantage of it. Instead, they always resolve everything on Second Amendment grounds. And, when you contrast that to like search and seizure, right? Article 1, Section 7 has an express right of privacy, whereas the Bill of Rights, the Fourth Amendment, does not. And so that means that in Washington, you have greater constitutional protections when it comes to search and seizure. And so this is like one of the few areas where the Supreme Court judges have the ability to make law, because nobody knows how much additional protection is afforded, right? And so, I want to start. And so because of that one fact that we have a right to privacy and the Fourth Amendment doesn't, there are so many different protections that we have. Like, for example, DUI check stops, right? We don't do DUI road stops in Washington because of our state constitution, because we don't do fishing expeditions. We don't just do random searches. We require individualized suspicion before we conduct a search. The same is true for randomly drug testing student athletes. And actually, let me back up just a little bit and think about the purpose that has to the DUI stops. Like, that would save lives if we had DUI road stops, like literally save lives. But because it violates our constitution, that's not something we stand for. We impose that as a principle. And I have a couple of others that I can work off, but I want to go back to the firearms. Article 1, Section 24, one of the things that you do is you look at the language of the text of this statute, and you compare it to the text of the Second Amendment. And there's no doubt what our framers' intent was.
Mhm.
They clearly wanted to give Washingtonians greater firearm rights. But so what is the context of that? We don't know. That's up to the Supreme Court to decide. Only the appellate court or the Supreme Court can make that decision. And I cannot recall, I don't think there is, I'm pretty sure there isn't, I don't think there is a single substantive ruling on that case. That would be something that I think that needs to be explored more on the Supreme Court. And you're the first person to bring it up. I've not seen, I've been asked a lot of questions, left-leaning, right-leaning. The Second Amendment doesn't seem to be, actually more specifically, Article 1, Section 24 doesn't really come up that much. So I'm glad you mentioned it.
Yeah, well, I feel like if things don't go our way with this election, they're going to see that as an opportunity to really push a lot. I mean, there's a lot of gun legislation every year anyway, but if the Supreme Court here in the state is the way they want it to be, then a lot of that stuff's probably going to get pushed through, and we're going to see even more of our gun rights eroded away in the state, which is unfortunate. So it's another reason why people need to actually vote this year.
And just so you know, I'm not giving any indication or promising on how I would rule in any way. I'm just stating facts.
Oh, absolutely. Yeah. Right. Yeah. So you've spent your entire 18-year career as a defense attorney fighting exclusively for the accused in the state. How would you pivot from a mindset of trying to find legal avenues to get defendants off or out on release to a judicial mindset where public safety and strict law enforcement are paramount?
Yeah, our justice system is made up of lawyers that wear hats, either a judge, a defense attorney, or a prosecutor. I could easily take my hat off right now and go prosecute someone. I mean, it's not my preferred work. I would prefer to represent real people in the system. And I do that because, I'm not trying to burn the system down. I know a lot of people do the work for that purpose, and I'm happy with them doing it for that reason, just as long as they're doing the work. That's not why I do it. I believe in the system. And so I could go on the other side and I could prosecute people, because I have kids that live in this community. And, it's a lot of times there are terms that are thrown around. One of my favorite terms, which is something I really believe in, but I feel like people don't truly understand, is the rule of law. I mean, do people really believe in the rule of law? You go to like other countries, do they have the rule of law? And what's the difference? Why do we have a rule of law? Well, it's because of law enforcement. You cannot have the rule of law without law enforcement. And so I believe our system can work, and that starts with law enforcement. If law enforcement does their job, the prosecutor does their job, the public defender or the defense attorney does their job, and the judicial officer does their job, I believe the system can work. And sure, there's going to be, there's going to be mistakes made along the way. We're human, right? But we can strive for that perfection. I do believe that it can work. But it means that everyone has to faithfully do their job. So I've been doing this at the ground level for 18 years. This is where the trial court record is made. This is where the Supreme Court, makes the law. It's based on these records. And I'll tell you what I've spent my career doing, because I do believe in the Constitution. I especially Article 1, Section 7, Article 1, Section 9. I can go through all of them. I believe in all of it. I'm a firm believer in it. And that includes firearms. And so I litigate these cases, and I litigate to expand these cases, the rights of my clients, in the context of these amendments, at a really high level. Sometimes judges don't even have the ability to keep up or understand the issues at hand. They kind of have an idea of how they're going to resolve it, and they're just kind of going through the motions. Other times I have some judges that are really engaged with the issues. They read all the materials, they understand it, and I'm having a great conversation with them. And I'd say most times, not there are prosecutors that can hang, but most times the prosecutors are taking a back seat, and it's just me and the judge having a conversation about what the law is, and what was actually being said in these cases. And so I'm just the type of person that I absorb everything. And I'll tell you that in that capacity, creating that record, that's where I can change the law as a trial lawyer, because I can always argue for greater constitutional rights. It's something called state versus gun law. And so I can argue that my client's case is different. It's different, and it deserves greater protection as long as I have a good faith basis in it. And I always do. I would never do otherwise. But the law allows me to expand constitutional rights, the rights of the people. It gives me the ability to do that. And that's all I do. I do it for fun. I do it because it's my purpose. And I do it because I just enjoy talking about the law. And so there's a saying that, only losers appeal. And so a lot of times I made some excellent records that would make for great new case law, but then I end up going to the jury and winning, or the case gets dismissed, or something happens to it, and I never end up, it gets resolved with a reduction of some kind. So the only way I get my stuff up there is if I lose, which happens. I'm not trying to say I win everything. And actually, I have a couple of things pending right now. But but when I do lose, what the most frustrating thing is that I go out and I make this record, and then the appellate lawyer doesn't raise the issue on appeal.
A lot of tax money in this state is being funneled into systems that seem more focused on managing a decline rather than actually stopping crime or enforcing the law. How would you use your position on the bench to restore institutional accountability and ensure the judiciary isn't just rubber stamping ineffective, costly policies?
Yeah, finding good judges is hard. It's that's a really difficult task to overcome. But I think that I'm going to bring a fresh voice. I think that I'm going to be the voice of reason on the high court, and I'm going to bring a level of transparency unseen in Washington state history. Being on the Supreme Court, you are the boss essentially of every lawyer in this state and every judge. And I'm learning a lot more about the actual power and control that they have over their judges. But they apparently issue these like trial court memorandums. I had no idea about them, but they issue these memorandums from the high court that trickle down. I don't think they're from the justices themselves. I think it might be from the clerk's office or someone that's given special authority to issue them. And they're not mandatory. I think they're all discretionary. But I think that's an interesting tool. It sounds like I don't see anything wrong with it. I don't think there's anything wrong with doing that at all, because the Supreme Court has jurisdiction over everything. That every superior court is under their jurisdiction. And so I think the big problem is judges not faithfully interpreting the law and applying it. That's number one. Standards are and I guess it has to start from the top, doesn't it? Like our Supreme Court
Mhm.
has to be able to model itself for the rest of the judges to take suit. And right now, we're just applying standards differently, right? Like there's a different legal standard that's applied for initiatives that are passed by the people, that makes it easier to strike down. But then a completely different standard is used for the capital gains tax that makes it very difficult to strike it down. So, that's first and foremost something that we have to do is lead by example. I plan to use that process of, I guess, trial court memorandums to try to steer our judges in the right direction. And I plan on using the rulemaking authority that the Supreme Court has. The rulemaking authority is strictly, I can't remember. I've had so many of these interviews. Did I talk to you about that? Rulemaking? Did we discuss that?
No.
Seriously, like 10 interviews. Um, Yeah, the Supreme Court has rulemaking authority. So there's already criminal rules, civil rules, rules on appellate procedure. They're all like finalized by the Supreme Court. And that's a massive authority to get the judicial branch completely in check and in line with what the Constitution demands. And the important caveat to that, though, is that it's really important that whatever rules are in place, they are strictly limited to process and procedure, because once it starts doing substantive law, that's where that's the job of the legislature. And it's the legislature's responsibility to make the law. So I think through the rulemaking process, we can get judges to start, um, enforcing the rules that are there. I don't even think they need to be changed much. And there is a commission right now. There is a judicial commission, and anytime that a judge is not faithfully interpreting the law, maybe yeah, there needs to be accountability. I guess I'm surprised that we have this commission and there's, I guess, no accountability, and maybe
Yeah.
that's because of who's at the top. I don't know.
You mentioned that Todd Bloom doesn't really stand much of a chance against the incumbent, but obviously Bloom has the official backing of the state Republican Party and existing statewide name recognition. While you're running an independent grassroots campaign, what is your specific pathway to consolidating the law and order anti-incumbent vote in the primary without splitting it and possibly handing it to Stevens in an easy win?
Oh, I don't think that's the case at all, number one. But I want to make sure that we're clear on something. You use the word independent grassroots. These are nonpartisan, so even though
Yeah,
none of us are going left or right or anything.
right,
Um,
right.
but Justice Stevens has all of the establishment support. She has all the union support. They love her for what she's done for the state. And they're not going to let their Lady Chief Justice go that easily.
Yeah,
And I think that when compared to a white male Republican, I think that the Republican's going to lose against this candidate, the establishment's candidate, the establishment's Chief Justice. I think that's easily going to be 65-35. Maybe, maybe not, maybe 60-40, but it's like, how close can you get with Todd Bloom? I mean, really. Uh, but I might provide an alternative to that. I think I'm her polar opposite. She's been all the way at the top at the Supreme Court. I've been at the ground level, and I understand what she does. I can play this game at her level. I've read all of the opinions that she lays down. I read all the concurring opinions, the dissenting opinions. So I understand the legal mechanisms that are at play, and I understand the issues that are presenting the voters. So, and I also have, I feel like, a unique ability to be able to like really take these complex issues of constitutional law and really like simplify them down to really easy to understand issues. And at this point, I feel like everybody is that is not wanting Well, I think that all Republican voters do not want the establishment. And when they look at the options that they have, they know they don't want the Chief Justice. And they look at Todd Bloom, and he's a really nice guy. He's a good tax lawyer. He served our country honorably as a veteran. And I think the one thing that they look at more than anything else is that he ran, two campaigns as a Republican. And so, at least I think for a lot of Republican voters, that would at least give them the confidence to know that they are at least, you know, putting somebody on the Supreme Court that shares their political values. I wish I could tell you what my political values are. I can't. I do have a history of doing, what I have. But I just don't think that he's going to be able to compete with the chief ultimately. The Chief Justice is this particular one. She's brilliant. She is the smartest lawyer in the state. I don't say that lightly. Um, it's not easy to write 78 pages without AI.
Yeah.
And to compete with that, I write long briefs. I think judges hate it. I love writing. I love legal writing, and I love engaging in these issues. And I see the pattern that she engages in, and I can call her out on it. I went through all those cases with you, all those taxing and spending cases. I have all the receipts on it. I have all the receipts on not just her case law and her philosophy, but just like what she's done with the branch, like the way she markets the court and the way she uses social media. She was there. Her and two other Supreme Court justices were raising the pride flag at the governor's pride ceremony. And, I think that the governor and the legislature, those are political bodies. They're free to, do whatever they want. But our Supreme Court is impartial. We're supposed
Supposed to be. Yeah.
and we cannot prejudge issues. And, like when you see something like that, like there's two problems with it. Number one, because we're gonna, it's the initiative is on the ballot, for trans rights. We're gonna face that issue. And it doesn't matter who, the left, the right, outsiders, what are people gonna think about whether you've already predetermined the outcome of that issue if you're raising the flag? I'm
Right.
sorry, that's a real problem for me. It has nothing to do with whether you support the flag or you don't. It's, and I'll put it on the other side. Like the 10 Commandments don't belong there either. The court should not be doing that. And, that brings me to my second point, is that if you are going to be doing this, for one thing, if we're going to make the exception, all right, let's open the doors and let everybody else in here too, because, we have to make sure that we're being fair about it.
Yeah.
And so, for me, I think I would have a very strict, I do have a strict policy against that. And, that was just one example. There's two more that I could share with you if you want me to, lay it on. Another one is, about domestic violence. And, our Supreme Court was promoting a really important and necessary message to get out to people, especially to the victims of domestic violence. And they discussed, they had a symposium on survivors and what they were experiencing. And then they came out with these, they're called Hope Cards. They're for survivors of domestic violence that have a no contact order outstanding. And it's something that they can keep on them so that if they are ever with law enforcement in some way, they can just hand them the card, and then law enforcement can quickly access the information that's needed. And I think the program, obviously it's a really great program. There needs to be resources like that. But it sounds like that's the job of a prosecutor or a police department, or the legislature branch or the governor. It's not the function of the judiciary. And just imagine how many people, right, are right now are in the courts, where there's no contact orders or protection orders, and there's child custody disputes. These are families, moms and
Mhm.
dads. And dads need, women get, I've represented plenty of women charged with domestic violence, but the, vast majority of them are, men. And, domestic violence is, they need to be held accountable. They need to be held responsible after they're given their due process. But it's so important that when they come to court, whether they win, whether they lose, whether they go to prison, whether they plead guilty, whatever, that there's confidence in the process. And when, the court is promoting these domestic violence using terms like survivor and these hope cards, when the court's doing that, like how is anybody, any person supposed to have confidence that they're going to get their day in court? That's a big
Right.
problem for me. Um, yeah, so that's another example of that. And yeah, I could probably just keep going on and on. I've got receipts of the stuff
Yeah.
that they've been doing, and I just it's not. I think that needs to end. And I guess it just really trickles down to the ultimate question you were asking about judicial accountability. It starts at the top. It starts at the top.
Yeah. Agreed. Okay, last question. You've spent your career practicing in King County, which is also your primary geographic base. To beat Justice Stevens, a challenger is going to have to win over voters across Eastern Washington and the suburbs who are deeply frustrated by the current bench. How exactly do you plan to build a statewide coalition in the next few weeks to survive the August primary?
One conversation at a time.
Yeah.
Yeah, unfortunately, I got in the game late. Um, I thought I could just do kind of a grassroots type campaign. I should have been more prepared for it. And that's unfortunate. That's going to hurt me a lot. But luckily, you know, Todd Bloom got to a slow start as well. And so I've hired a campaign consultant. So I have a professional fundraiser now. I'm starting to gain support. I just started getting my system going. And while I'm not nearly raising as much money as my Chief Justice opponent, she's got like I think 30,000 last time I checked. It might be more now. I've got donors now. I've got a momentum, and I'm starting to make calls to try to get them to donate to my campaign because I really do believe that I have a chance to beat the chief. I believe I'm the only chance. I'm sorry. I know yeah, Todd Bloom's a really nice guy, but I just don't think that he has a chance against the Chief Justice. I am going to try really hard to earn the vote of Washingtonians, and it's going to happen one conversation at a time. And I just really appreciate you giving me the opportunity to talk to you about this.
Yeah, well, I appreciate you being here today. If people want to find out more about you or donate to your campaign, where would they go?
The first place would be Facebook. I really express my First Amendment rights on Facebook. But I also have a website, karim4wa.com. That's
Okay.
the number four, karim4wa.com. And I have TikTok and Instagram, and those will get moving shortly, but generally on Facebook and my website. And if there's any
Okay.
of your viewers that ever just want to have a conversation, I'm up for it. I can do a Zoom call like this. I can just FaceTime on Facebook, whatever. I'm happy to talk about the issues.
Okay, great. Well, thank you for your time and being here today. I really appreciate it.
Great. Thanks so much.